if you have done something that is right under the old act, and if you continue the terms, the intention of law is that they will be good until they expire. General clauses, yes. The next question is, how would dividend, bonus, rights issue be allocated to differential equity? All three rules were correct, go ahead. So whatever are the terms of that particular instrument is something that would go in terms of the differential voting rights. A question comes, and which is a very valid question, that assuming that my differential voting rights are at 26% and 74% are non-differential vote. So 74% is non-differential, 26% is already there as differential. I fulfilled my quota. Now the company does a rights issue. And the rights issue, as we discussed, needs to be issued to both of them, or at least offered to both of them. Assuming that the 74% don't subscribe, and the 26% subscribe, their percentage will go up, but they cannot, because 26 is the ceiling. What is the repercussion in that situation? I have reached that ceiling of 74% or 26%. I cannot subscribe because there is a legal threshold. Still, I am offered something. I do not know whether the balance 74% are going to subscribe or not. What do I do in that? There's no clarity in that. My sense is that you will have to mention in the rights issue letter of offer that, if the 74% guy do not subscribe, you are not going to get shares. Or if they subscribe, you will pro rata get shares in the terms what they subscribe. And essentially you might not be able to reach the 26% threshold, but there is no guidance, but yes, that's my question. We come to public issue, change of objects. Now this has been one section under the old act. Any idea what was the section that deals with change in objects in a public issue? Any idea? I think something knew that, right? 61. Section 61 says that once I have raised funds for a particular object, I can change those objects by passing a resolution in my general meeting. That's what the old section says. The new act says that yes, you can do that, but there are some requirements that you need to fulfill. And if some small shareholder says that no, I don't want you to change the object, the promoter or the controlling shareholder will need to give an exit to that minority shareholder. We talked about majority versus minority. One classic example where majority will have to mandatorily buy out a minority. So dissenting shareholders need to give an exit in case you change the objects of an issue. Valuation of the same and all other things will be given by SEBI, which are currently not out. But yes, the provision is here that if you change the object, dissenting shareholders need to be given an exit and you need to comply with the formalities. What are the other considerations? So one is postal ballot mandatory? All three groups were perfectly correct. Yes, it is mandatory. You also need to give a newspaper advertisement in 2 local areas so that people are aware that this is what you are planning to do. And also the explanatory statement that goes along with that particular notice needs to be elaborate and mention things that would capture the intent and give proper information. If few shareholders do not agree, then yes, that's the purpose of it. This is again encroaching on SEBI territory. A third party regulation in classic play where SEBI could have brought in a regulation, but you are getting into the listed company zone and telling me that this is how you need to do, and then telling SEBI that please do this. So classic third party regulation is there. The next case study is change in terms of preference share. Now these are redeemable preference shares that a company has issued. Now it doesn't have funds to redeem them, and the management thinks creatively that we will convert them into equity shares. And there is a provision under the Act Section 48 which says that the variation in terms you can do. So can I do that? Is the question that case study deals with. And I think one group identified it very correctly, and the guys who were sitting outside as shareholders, is that this section is not notified. So 48 as a section is not notified. The first highlight in this case study is that whenever you check into a section, you need to make sure whether it is notified or not. Many a times you would advise based on this 48 that yes, before the preference shares will consent and you go ahead and do that. But if the section is not notified, you need to go under the old Companies Act. Because that is still live. Both the acts will run parallelly for at least 2 or 3 years, as I see it from here. What happens if a section doesn't have a corresponding section? Like for example, the new act has 470 sections. The old act had around 650 sections. It is possible that there is no one-on-one correlation to that section. What happens to sections which don't have a corresponding provision in the new act? My view is that until section 465, which is repeal and saving, is not notified, all those sections that do not have a corresponding section will continue. But yes, once the new act has a section, to that extent the old act is repealed and stands cancelled. And this is something that we have tried under the old act, and I am saying from my experience where we have tried to convert this redeemable preference shares into convertible, and it was a listed company. Maybe I can share the name offline. But essentially what happened is that the promoters didn't have the funds to redeem the shares. You can redeem only out of profit or your fresh issue. They didn't need to do that, neither had the capacity to do that. They wanted to convert it into equity. So they managed to do that, and matter was also approved by SEBI and even the ROC, subject to the thresholds that a listed company has in terms of creeping acquisition. So it did not exceed the 5%, but we took resolutions of both the 3/4 of the preference shares and also 3/4 of the equity share. So if tomorrow someone says that look, the equity shareholders' rights were affected by that, then we took their resolution as well and they also consented. Now under the new Companies Act, the issue will be what value? Because I am converting the redeemable into convertible. At what value can I do? The old act had no valuation requirements. In the new act, you would still need to do the valuation. One view is that when I had issued preference share, I would have taken a section 62 resolution or a member's approval, then only I can issue preference shares. So I don't need to go again. Second view is that no, you had taken under the old act, wherein there was no valuation. Now you have valuation requirements, so do that. I would feel that you need to do valuation. Anyways, for SEBI purposes, you have to do valuation on the market price link. To do that valuation, and if you can convert, then you can convert if this section is notified later. Coming to the last topic of deposits, and this is again a limited company which has certain deposits. A lot of chaos is there in terms of what is deposit, what is not deposit, when do I need to repay, what can go for 60 days, what can go for 1 year, when do I need to fill the form DPR4, and all those things which are floating around. Now it seems to be settled because now we are at least 6 to 7 months in implementation. But at least understanding conceptually, this company has share capital authorized and paid up. Is paid up a deposit? Of course not. Is general reserve a deposit? Share application money? Share application money pending allotment since 2010.
Yes.
Under the old act? Under the new act? Okay. Securities premium?
No.
Profit and loss account?
No.
Non-current unsecured loans from holding company.
No.
So holding company is giving me non-current unsecured loans. What is the reason? ICDs. So I would suggest everyone going through at least one rule, that is the acceptance of deposit rules 2014. If you cannot go through the entire rule, only go through the definition of deposits, which is in section 2, the regulation, sorry. And it says that any money that I receive or any loan that I receive is a deposit except for the 14 carve-outs that it has. And we all need to understand what are those 14 carve-outs. If it is an ICD, it is not a deposit, which is very clear. From directors, yeah, so you can take money from your directors subject to the directors not borrowing it and giving you a certificate to the company that yes, this is my own money. Now, let's take an example where a director has significant net worth of 5 crore rupees, but he doesn't have liquidity. And he borrows 1 crore and lends 1 crore to the company. So there is a trail from 1 crore which I take from the bank and I give 1 crore to the company. But essentially, if you see my balance sheet as a director, I have 5 crore of asset minus 1 crore of borrowing. So I have a 4 crore positive net worth. Can I give deposit to the company or can I give money to the company which is non-deposit? So over here, there are certain judgments, and as a practical view, what people have been doing is that I can give to the extent of my positive net worth. So if my net worth is positive to the extent of 4 crores, then I can give loan to the extent of 4 crores. I mean, how much it will work under the new Companies Act is to be seen, but under the old Companies Act, people used to give to the extent of the audited net worth of that particular director. From members, it is a deposit, but there are certain restrictions in terms of what you can take, what you cannot take. but it is still a deposit. Under the old act, was it a deposit? No, I would have taken for my members. Under the new act, it is deposits you can still take subject to certain restrictions. Now, this is a subsidiary company of a public limited company, and it has taken loan from members. Assuming that it would have taken loan from its holding company, does it need to comply with the ICD or does it need to comply with the members? I am Bombay Private Limited. I give loan to my subsidiary, that's Pune Private Limited. I am a shareholder of that company, and I am also a corporate. The deposit definition says that ICD is outside deposit, members subject to those regulations. So can I take a stand that this is an ICD and I don't need to comply with the members regulation? My view is that you might be able to do that because you have a specific exemption of ICDs. But when you are giving it to a non-member who is not your holding company, does this existing loan count in limit is the question. Like you can give up to 25%. You can accept deposits up to 25% from your members. Now assuming that you have taken 25%, which is from an ICD. Now an individual member comes to you that I want to give 1 lakh rupees to you. Then can I take? Then I think it's challengeable because essentially in your membership quota, you have already fulfilled that the 25% which is there. Then it can be challenging, but yes, the view in earlier situation is that if it is an ICD, you fall under that exemption and give as much as you want to give. Subject to section 185, 186, which are other provisions, but yeah, deposits focusing on. From promoters. From promoters cannot be body corporates, ideally. So it's an individual. Promoters need not be my shareholder. It can be my ultimate shareholder also. As Nilesh explained, there can be a web of companies, and that web of companies owning my company. Promoter could be the ultimate person. Now for a subsidiary company, my subsidiary is also my subsidiary. But is my shareholder, my shareholder. For subsidiary, you can say that my state-run subsidiary is also my subsidiary. But is a shareholder my member? Not, because it is not in the register of members. So if a promoter, hence it is a separate exemption, and you can take from promoters, subject to the banks enforcing a condition on you that they will lend only subject to you bringing in your promoter's contribution. And until such time the bank loan is outstanding, you can keep those promoters' loan. After that, they will be termed as deposits. Many of creative professionals have started getting a letter of sanction from the bank or maybe amending their loan agreement to say that I am giving you additional cushion. I am giving you additional promoters login. But you write in your sanction letter that this is what I am willing to get from the promoters. And then you can go and give it to the company as deposits. Then we come to 0% optionally convertible unsecured debentures. These are unsecured debentures. Financially jargons in terms of 0 coupon optionally convertible for 2 crore rupees. Is it a deposit? This was a mixed view. Now, conceptually, if it is a secured debenture, secured by first charge or a pari passu first charge on tangible assets of my company, then it is not a deposit. Or compulsorily convertible debentures, subject to a maximum of 5 years convertible, are not my deposits. But any other kind of optionally partly convertible debenture will be a deposit. So 0% convertible unsecured debentures will be a deposit unless it is from your member shareholder ICDs. 12% non-convertible unsecured debentures from members. So this is non-convertible unsecured debentures. Can you do unsecured debentures? There are two tests: secured debentures, first charge, and compulsorily convertible. Unsecured debentures will be treated as deposits, but the second part is from members. So if it is from members, again you have to have that 25% exemption, and you have an ICD exemption that you can take care of. If it is from other companies anyways ICD, you can do that. But if it is otherwise an unsecured debenture, you cannot do that thanks to the Sahara issue, who has millions and millions based on unsecured optionally fully convertible debentures. What will be the treatment of such deposits under the Companies Act 2013? Can the company continue such deposits? So we discussed that what will be the treatment. The problem is that I have already taken such funds under the old Act. 1st April comes. Now what do I do? So they have given a transition period that you can have up till 1 year, and from 1st April 2015, you need to repay it. The problem comes in share application money, where they say that share application money can be taken only for 60 days. So we tried to seek views of the MCA, we didn't get proper feedback. We tried to write queries to the ICSI, the Institute of Company Secretary. They have an online posting where you can ask a query and they respond pretty quickly within 2-3 days time. And we asked them that can I hold share application money up to 1 year? The response was no. That because you have the 60-day threshold and plus 15 day, you need to ensure that those are repaid before the 60 day, and you might not be able to have that 1 year time period for share application. People have taken different views practically. ICSI's views might not be the final view, but essentially what they said is that share application money, you don't get that 1 year transition period.
Just maybe if you can answer the question that we debated this point. What's the view on some aspects which are not deposited in the old Act and have now been covered in the definition of deposit?
That's the example of share application.
Or optionally convertible debentures.
Or optionally convertible. So for optionally convertible debentures, again, you don't have a fixed time. So one view is that you can continue up till 1 year. We have done a couple of instances where we have continued up to 1 year.
Why even 1 year? That's was the point which we are debating. Why even 1 year? Because even if the definition starts with the word no deposit shall be continued now, it means a deposit with the new Act.
Yeah.
Because your old deposit.
So they don't say deposit in the new Act. They use the word deposit. They don't say deposit in the new Act or the old. That's the whole confusion. But if you go by the spirit of the law, they are giving you a transition period. I want that, look, you should not face a liquidity crisis on 1st of April. I'm giving you 1 year period to ensure that you repay all these things, clean up your balance sheet, and from 1st April form a new scheme which is in compliance with the new deposit agreement.
Using Sahara will repay everything this 70,000.
Then seems behind the bars.
Which is fine, but as a company, it has to also do this.
So essentially, that's what the view is.
Vikram's question since people have taken money, they invested in real estate, whatever. They are not able to liquidate anyway, but that's the ground reality, but law is the law.
And also they have given an option that you can go to the tribunal. Problem is tribunal is not notified. They came out with some clarification that tribunal will be regarded as CLP and it comes whenever it comes. But essentially, there is a provision you can go to the tribunal and seek for an extension of time. They will decide on merits of it. But it's not tested as yet because everyone has a 1 year period. But my view is that you cannot extend forever. You will have to stop it at 1 year. Or if they are getting repaid earlier, you will have to stop it earlier and not even extend till 1 year. The next is, can Pune Private Limited accept deposits from public? Now this is a private limited company, right? Pune Private Limited. Can it accept deposits from public? Again, mixed views over here. The thing to be identified is that it is a subsidiary of a public company. It's Bombay Limited, which is owning Pune Private Limited. There was a concept of deemed public limited company and all of that under the old Act. The new Act, in definition of subsidiary, has said that even a private subsidiary of a public company, for all purposes, we need to comply with the provisions of a public company. So the question is, can we then allow a private limited company to raise deposits? And extending that logic, can a private limited company go for an IPO? Because essentially it's a subsidiary of a public company. Its status is a public company. Can I do that? I think if you read very strictly that definition of subsidiary, which includes, I think, definition in 287, that's the definition of subsidiary, you would get an impression that whatever are the onerous provisions will apply to a public company, even that private limited company will have to follow. But it is not very clear if there are some benefits available to a public limited company, whether I can take that or not. And take it in writing that the SEBI will not allow a private limited company to get listed, because when you go in the RRC, it is going to stop, even if you take a pure legalistic view. In the RBI, when you file a circular for deposits, you would ideally not have, or the ROC, you would not have a private limited company to do that. But this opens a debate in terms of status of a private subsidiary of a public limited company. Like, loans between two public limited companies are exempt. So if I give loan to my 100% private limited subsidiary, is it a deemed public limited company and can I exchange funds? Does it need to comply with all the regulations which are applicable to a public limited company? Are all challenges that are coming because of this definition? But yes, whatever is more onerous, you need to comply with the public regulations as well. Can preference shares be issued at a premium? Preference shares issued at a premium. Why would you give premium to a preference share? It's a redeemable preference share for say 8%, 9%, 10%. But why would you give preference or premium to a preference share? Forget section 56 and the tax aspect of that. But on the company law, does it make sense, or is it in the interest of the company to issue preference shares at a premium? People have done that. There are instances where preferences have been given at a premium, but it is open to challenge as to what is that premium for. I am going to get a fixed 7%, 8%, 9%. If it has certain additional rights attached, then you can justify the premium. But a pure vanilla premium, even though people have done, it can be difficult to say through why you offered that premium for that preference share. And then we have two additional questions. One we covered. Second is whether LLP will be a subsidiary. Anup is here and he's going to tomorrow brainstorm on the LLP in extensive depth. But since we are talking about holding subsidiary, will LLP be my subsidiary? Under the old act, I could have formed an LLP. Is it a subsidiary? The definition of subsidiary, if you read clearly or clearly, it will now also include an LLP. Because it extends to body corporate and not to a company. And essentially, even if I have a 100% LLP, it can be a subsidiary for my purposes. Problem is, will it be a public subsidiary or private subsidiary? We are going into depth, but yeah, essentially, you can have a subsidiary within the definition and it can still get an LLP.
Can LLP be the holding body corporate?
LLP owning shares in a company?
Yeah.
Absolutely possible.
So, what will be the kind of the company? Will it be private or public?
No. So essentially, if LLP is your shareholder, your status of the public company or the company will not be changed. Because your LLP is not public. Your LLP is under the LLP Act.
It's not a company which is a private company. It's not a body corporate which is a private company.
It is not a public company. Only a subsidiary of a public company will be a public company. Now, LLP is not a public company. So, you don't go into the logic into what will be the status of its subsidiary, because it in itself is not a public company. Whether valuation could be a base or a range, I think the rules suggest that valuation can also be a range, and the valuer can give a range within which the board can decide that this is the fair valuation and issue shares. We have also seen instances where the valuer has given one rate on which the shares have been issued, and sometimes the valuer has also given a floor above which the board of directors can go ahead and issue. All three are currently possible, and the rules also seem to suggest that you can also have a range which can be input. Perfect. So it brings me to the end of the case study. I overshot by about 10 minutes, but we compensate in dinner. Any other questions, we can always discuss those. I would like to end my session with a small joke which I was reading when I came here, and Parimal was with me. And I got an SMS which was a joke essentially, but I could relate to what is happening under the Companies Act in that. So what was the joke? That train is going on the tracks, and it has some 500 passengers. All have paid valid tickets and are sitting in the train, and the train driver is coming the train. And some person comes in between the tracks, and the driver essentially is surprised that what do I do now? And the driver takes a detour and takes the train into the farms. and finally an inquiry, and people suffer, there is loss of life, loss of death. And the inquiry is set up, and the driver is asked that why the hell will you take into the farms? If that one person is on the tracks, you might as well move over him. That is what you have been taught. You cannot risk the life of 500 passengers for one person who is on the track. So the driver said, I was doing the same thing. I was punishing that one person. But he went into the farms, so I have to go into the farms. So that's what the regulators are doing, to punish one individual who is going into the farm. You are taking the whole train into the farm, assuming that every one of us are SRKs. It might not be that. So needs a reaction is very much evident, and I thank you very much for a patient listening. Looking forward to meeting you. I didn't speak that.
We welcome our next faculty for tomorrow morning, Anup Shah. Friends, we all will agree that Anand has expanded our horizons by making us creative consultants. And it takes a lot of time, maybe hours and days together, to think, churn and write the paper and meet the expectations.